Hi, friends. Welcome to Immigration News by Ting Law. I'm your host, John Ting. We practice immigration law in Houston, Texas, and all 50 states of America and across the world, representing immigrants to live and work in America. Now, we want to find a path for you. Hi, friends. If you're new to our channel, please hit subscribe below so you can get all the notifications of our future videos and news, and smash the like button. Today, we're going to talk about the recent order that just came down from the district judge regarding the proclamation. Now, you might be wondering, what is this whole thing about the proclamation? Now, you might remember back in April of 2020, President Trump issued a proclamation to essentially suspend all visa processing. So no one can come into the US for any type of visa except fiancé visa. But at the same time, he closed down all the consular posts, which means the U.S. consulate offices. So even fiancé visa, even though the order said that they can process, he still shut down the consulate office unless there was an emergency situation. So now it's September. So that's about 5 to 6 months since that proclamation. And finally, we've seen some movement. Last Friday, there was an order based on a temporary request for temporary injunction. Friends, a district judge ruled that the exclusion of diversity visa applicants from the exception to the proclamation, which basically the exception meaning allowing visas, was arbitrary and capricious because it's more of a timing issue in terms of lottery winners, unlike the family-based or the employment-based visas. There are several different people involved with the plaintiffs, and with that is different classes of applicants. One type of category of applicants include diversity visa applicants. Another category is for the family-based applicants, and for example, like through siblings or parents or children, and also another category for employers. So they're part of the lawsuit as well. So all these people, we call them plaintiffs that are suing the government, President Trump's administration. The quick answer here on what the order ruled is that the district judge, Amit Mehta, ordered that the diversity visa applicants who won the diversity visa are granted this temporary injunction. So this means that they are able to process their actual visa. Number one, they've been selected in a lottery. Number two, they have to get the visa. And so they have to go through medical exam, fingerprinting, and the actual interview at the consulate. And so that all that has to be done by the end of September because the fiscal year ends at the end of September. And these visas get recycled or basically expire at the end of every fiscal year. So the government runs on a fiscal year ending at the end of September. Now, this is very important about the timing, and that's why the district judge only granted temporary injunction for this specific category for DV applicants, because there's not so much of a rush or emergency situation in terms of timing for the family-based applicants and also employment-based applicants. That's why the judge denied the injunction for those latter two categories. So although it's good news, there's also bad news, right? But of course, it depends on the law. Most people assume that this judge was appointed by President Obama, that he's going to just rule in favor of immigrants, anything immigration-wise, right? That's not how it works. They have to focus on the law. And it was the opinion, the judge's order was actually 85 pages long. So he actually took, like any judge, took a very serious approach to this and considered all the factors. But the main reason that the judge allowed the injunction for the diversity visa applicants, in addition to the timing, is because a judge, in granting this temporary injunction, believes that there's irreparable harm, meaning immediate harm, since the deadline is very close. The judge ordered on September 4th. So district judge said that Department of State and the government cannot continue to use the excuse of the COVID-19, the pandemic, as a reason not to issue the visa. Now, these visas are normally valid for 6 months, but they have to be issued the visa in the first place, and the State Department has not done that at all. So what the judge also ordered is that they come back to the court on September 25th to provide a list of those who were actually gone through the process for the issuance of the visa, and also another list of those who did not get the visa at all. So you can get an idea of who's left to be accounted for. So here's a tidbit from those 85 pages is that even though the judge did not grant an injunction in favor of the plaintiffs for the categories of the family-based and employment-based, here's a nugget that you should take into consideration. And the judge said that it is likely that these plaintiffs can succeed on its merits. And so, again, September 4th, last Friday, was only about a temporary injunction. It's basically, you can call it like the halfway point. So there'll be a final trial later on, and what we call merits, meaning the facts, to review whether the other plaintiffs will win. And so that could open the door again, and meaning scheduling interviews for these applicants, which is important. A lot of our clients, a lot of our colleagues' offices, their clients are waiting, even though the previous application has been approved already, the petitions haven't been approved. And so we're all just waiting around, ready to go and get the fingerprinting and medical exam scheduled before the interview. So another thing to note is that the judge declined to tell the State Department to reserve the visas, the diversity visas, if they're unable to process all the diversity visa winners. And so that's alarming, because they can essentially just go to waste if they're not officially issued out by September 30th, 2020. And the judge also declined to force the government allow the processing of these visas, and which means a medical and the interview of these applicants past September 30th. And he did not believe that he had the authority to do that. He probably thought that's up to Congress. Friends, I know you enjoy the news that you're getting from us. We try to do our best to provide you the news in short videos, and so that you don't have to read orders like this that is 85 pages. But if you're interested, we'll find the link to it so it's public view, and we'll put it in the description below. Hi, friends. If you got value out of this episode and yet you're not a subscriber yet, please hit subscribe down below at the logo. Smash the like button. If you have any questions about this, please leave a comment below. Schedule appointment, our link is below. Please leave a comment below. Tell us your story if you've had issues because of this proclamation back in April 2020, because the more people that speak out about this, then we can gather more, we can advocate, and as a coalition, and share that information to a judge.